Hello, everybody. Attorney Ryan Knutson here. Today, I want to discuss when landlords break the law and when tenants uh, fail to recognize that landlords are breaking the law, fail to evaluate the situation, and leave rental properties when they had no reason to leave and when the landlord's notice to terminate tenancy or eviction wasn't valid. This is a situation that is happening across California. We live in an age where the law, federal and state, is increasingly under pressure and is being constantly tested and is under great stress. I see this in my own practice in the areas of civil rights. The civil rights laws are being violated and tested everywhere you look by the government and also by private parties. But I also see this in the landlord tenant context. I specifically see this when it comes to landlords who serve what are called 60-day notices to terminate tenancy or 30-day notices to terminate month-to-month tenancy. So in California, these notices to terminate tenancy, where based on a month-to-month tenancy, are invalid. They are illegal and they are not effective generally to terminate a tenancy. Here's why. So in California, before 2021, California did not have statewide rent control. This means that the California legislature had not, before that time, passed a comprehensive rent control or just cause for eviction ordinance that applied throughout the state, even in cities and counties that didn't already have a rent control or just cause for eviction ordinance. Um, a law that applied throughout the state to properties that were not previously covered by any kind of eviction control or just cause for eviction control. Before 2021, that law did not exist. After 2021, the Tenant Protection Act of 2019, passed by the California legislature in 2019, came into effect. And the Tenant Protection Act provides that landlords must have a just cause for eviction when they seek to terminate a tenancy and where they seek to evict a tenant. The rules are a little complicated, but essentially we now have statewide just cause for eviction protections. Um, I will also mention that even prior to 2020, prior to 2019, 2021, 19, 2021, 20, and 19, individual cities and counties had a local just cause for eviction protections. For instance, Oakland, California, and San Francisco, California, and Los Angeles, California, the bigger metropolitan area jurisdictions had some form of just cause for eviction protection. This means that there was a law in place passed by the city council or the county board of supervisors that prohibited evictions except for certain just causes. Now, when you look at the state law and when you look at local law and ordinance, all of these eviction protections, just cause for eviction protections together, what they essentially did was they limited evictions. They prohibited landlords from evicting their tenants except for the enumerated just causes, except for the limited just causes, the stated just causes in the law and the ordinance. So under state law, I believe there are about 9 just causes now. There are both at-fault just causes, at-fault meaning you fail to pay your rent, you destroy the property, you commit a nuisance, things of that nature. And then your no-fault just causes, which include substantial rehabilitation to the property, significant repairs, and owner move-in. The statewide law and the local laws are very specific. They provide the exclusive just causes for eviction. So there are exceptions to that, but they provide the exclusive just causes for eviction. So where you are a tenant and you're on a month-to-month tenancy and you live in California, either you live in an area where the Tenant Protection Act applies because you're in a jurisdiction that didn't already have a local rent control or local just cause for eviction control ordinance, or you're in a city and county that has a just cause for eviction ordinance or protection, um, if you are in these areas, you cannot have your tenancy terminated simply because it's a month-to-month tenancy and the landlord states that they don't wish to renew the tenancy. So how that generally looks is if the landlord says you're on a month-to-month tenancy, either in a written agreement or you had a written agreement for a year and it expired, and now you're on a month-to-month tenancy. Prior to 2021, throughout the state, the landlord, unless you were in a just cause for eviction protected city or county, the landlord could say, okay, you're on a month-to-month tenancy. I'm going to give you written notice for 60 days, and now you're required to leave because I don't wish to renew your month-to-month tenancy. That was a legal basis for evicting a tenant throughout California where there was no just cause for eviction control prior to 2021. That has changed. Throughout California, right now, generally speaking, if you are in a property that is not an exempt property, there are certain exemptions from the statewide rent control, just cause for eviction ordinance, just cause for eviction law. A landlord cannot terminate your tenancy with 60 days notice if you're a month-to-month tenant. Basically, a 60-day notice would mean that the landlord has no reason for terminating your tenancy other than they don't wish to renew your month-to-month tenancy. That's the language contained in the notice. So if you are a tenant in California and you have received a 30 or 60-day notice to terminate month-to-month tenancy, you need to, number one, look at the state law. Number two, verify if you are subject to the state law, if you're protected by it. There are certain exceptions. Some of these are that you live in an educational institution, you're in a nonprofit hospital, you live in the landlord's house and you share kitchen or bath facilities with them. The landlord owns a single-family home and rents no more than two units in the single-family home. So there are certain exceptions to that. But generally speaking, if you receive a 30 or 60-day notice to terminate tenancy, be wary and check and verify whether it's actually lawful before you leave. We get a lot of cases where tenants have already left and they can't return to the property, obviously. But if you receive one of these notices and you leave in response to it, well, the landlord was under the obligation to figure out whether their conduct was legal. They had to figure out whether it was legal. You've been wrongfully evicted. So at that point, you should still contact an attorney to discuss your options. But generally speaking, to sum this up, in California, month to month, notices to terminate tenancies, 30 or 60-day notices to terminate month to month tenancy that simply seek to terminate the tenancy because the landlord does not wish to renew it, those are generally not legal or valid in the residential context. More on this to come. Thanks so much for listening.